Allison Jones, is legal representation. She's the lawyer representing Fair Park Alumni Association and concerned citizens. Hey, Ms. Allison, how are you this morning?
Good morning. I'm doing fine.
So the latest is, will you explain to us, because it's sort of we're going constitutional on everybody. Explain to us what the deal is.
Well, the United States Constitution provides under the 14th Amendment for equal protection of all citizens. And what we've alleged is that because the school board has chosen to merge two black schools with mostly black populations, that they are asking the black students to bear the burden of any economic concerns that they have in the district. We believe that's a violation of the Equal Protection Clause of the United States Constitution. We also believe it's a violation of the Louisiana Constitution. We point out that we do not believe that racially neutral options were considered, and that even if there were compelling interests, which we don't think there are in this case, that they were not narrowly tailored.
What do you mean by racially neutral?
When we're talking about racially neutral options, we're talking about, do you have the ability to accomplish what you hope to accomplish as a governmental interest by sharing the burden of that governmental interest in a way that is not just borne by one race. In this particular case, you have one race bearing the burden of whatever the compelling reason is they want to articulate. Racially neutral options would be considering the merger of perhaps schools that were more diverse in order to achieve more diversity. As you know, the Caddo Parish School Board is still under the 1981 consent decree, particularly as it relates to Fair Park and Booker T. Washington. And so the question then becomes, well, if you merge these two schools, what have you done, if anything, to further desegregation? Well, you've done nothing to further desegregation. Those are the concerns that are raised in the lawsuit.
It sounds to me like you are in this lawsuit representing Booker T. Washington students as much as Fair Park students. Is that fair?
Well, I think what we've alleged is that we are representing Fair Park students, but I certainly believe that representation will have a beneficial effect for Booker T. Washington students, because we've alleged that the merger of these two schools will cause irreparable harm in that it violates their constitutional rights. Now, the Caddo Parish School Board may argue, well, we have a contract, with other parties. Well, you can't contract away constitutional rights. And so, we can't anticipate what their defenses are going to be, but we still believe that there is a constitutional violation under the United States Constitution and under the Louisiana Constitution, and thus this merger should be stopped with injunctive relief. Isn't
there some small irony in that you are saying that an African-American superintendent of schools of Caddo Parish, in this case Dr. Gorey, is being racially insensitive to other black students?
Well, I don't think we're necessarily saying that Dr. Gorey is being racially insensitive. When the proposal was first made, he was surprised by it, requested from the Caddo Parish School Board that they be given time to further study it. And the Caddo Parish School Board rejected that request from him and went ahead and voted and moved forward with the motion. So it's not directed at any particular individual. School boards make decisions all the time. In this particular case, we believe they hastily made this decision, and in doing so, they violated the constitutional rights of the students of Caddo Parish.
Talking with Allison Jones, one of the attorneys filed lawsuit against the Caddo School Board with regard to the Fair Park BTW merger. What do you hope happens now? I know you've asked for a temporary restraining order. How quickly could that happen?
Well, I have no control over the timetable. The timetable will be controlled by the court and the judge to whom we're assigned, and we don't know who that judge will be yet. Hopefully, we've asked for an extraordinary relief. We understand that we're asking for an expedited extraordinary relief. We believe that the extraordinary students of Caddo Parish deserve no less. But that decision will be made by the judge. If the extraordinary relief of the temporary restraining order is not granted, we believe a date will be set at some point in time for a preliminary or permanent injunction.
Obviously, there have been cases like this in court previously across the country. Usually, what is the defense of the school board in defending actions like this?
Well, we believe that the school board will allege that they have to take some action for economic reasons. I can't really anticipate what their defenses are going to be. I can tell you, however, that in reviewing the minutes of the Caddo Parish School Board and reviewing the justifications that were proposed for this merger, none of those reasons articulated are compelling reasons, none of them are narrowly tailored, and none of them considered racially neutral options.
If there is a school system where you have a school where the enrollments are declining and you do need to close a school, what is your suggestion with regard to the best alternative for all involved? What could these students from Fair Park been moved to Shreve or Byrd? What would have been an option that you would have and the alumni folks would have been happy with? They don't want Fair Park closed at all.
Well, that's right. And the question is, under the consent decree, was Fair Park given a fair opportunity to survive and thrive? And I think that what the students, anytime a school board is met with this type of decision, it has to study the decision and it has to ensure that it is complying with the Constitution. I'm not going to step into the shoes of the school board and tell them what to do. What I'm going to tell them is whatever they do has to comply with the United States and the Louisiana Constitution.
When you say survive, not given the chance to survive and thrive, am I off the mark in inferring that what you're saying is that Fair Park is getting the short end of the stick from Caddo Parish?
And has historically gotten the short end of the stick, as have other schools in Caddo Parish, yes. And that's the reason we still have the 1981 consent decree. So at some point in time, even though we've brought this extraordinary litigation, we're going to ask to intervene in the consent decree litigation to see if we can't get some equity in Caddo Parish.
Pardon me. So in your opinion, the short end of the stick is racially motivated?
Well, that's been the allegation against the Caddo Parish School Board all the way back to the initiation of the consent decree litigation in the early 60s. And I think what people have to ask themselves is, have we made any progress since the early 60s? And if you look at Caddo Parish, I think you have to fairly judge it as we've made very little. Now, I understand the Caddo Parish School Board is going to take a different position, but they're still under the consent decree with respect to certain schools, and I think they have not complied with their obligations under that consent decree. That's not necessarily for me to decide. That's going to be for a judge to decide, but we're hoping to be able to intervene in that litigation and present that type of evidence.